Representing the appellee, Katie Audette, is Charles S. Martin.
Thank you very much, and good morning, everyone. Mr. Orost, can you hear me, sir?
Yes, sir, I can.
And we can hear you. You understand you have 5 minutes, and we'll try to give you an alert just before your time expires. So please go ahead.
Thank you. Yes, I'd like to start with the abusive litigation matter. I'm not actually sure I'm doing this right, but I'm going to just go ahead and read what I've got, and if I'm wrong, please stop me and say, you're wrong. Abusive litigation has 4 prongs that must be met, A, B, C, and D, and this is in Judge Bent's rulings. I think that's what we're discussing. So in 1181A, in the abusive litigation, former household member, that one is met. B, found to abuse other parties, that's met. 1181C, being advanced to harass other party. She has a lawyer. Motion for injunction was due to the retrial request. The injunction was one of the excuses Judge Bent used. 1181D, this one, at least one must apply in 1181D. And this is the one where it gets kind of squirrely. It has I. So I is not warranted by existing law, and that's incorrect. It is warranted by existing law. It's a divorce. So that one doesn't apply. Allegations without evidence. No, there's lots of evidence. That one does not apply. Number 3, issues previously filed in one or more other courts or jurisdictions and dispensed of in unfavorably. That one does not apply either. So I'm going to say that D does not apply and all must apply. So abusive litigation should not be used in this case because D does not apply and C does, I'm going to say, does not apply either. So it cannot be used in the same divorce case and the same venue, because this case is a divorce case in the same venue, and D very distinctly outlines that it has to be in one or more other courts or jurisdictions and dispensed of unfavorably. So this is not in other jurisdictions. So if we're going to follow the law, we really need to make this go away. The civil case also at the Supreme Court was filed after the divorce. So that doesn't count as another case. Retrial request and in the same venue. So the civil case in Lamoille County, both cases are in Lamoille County, and they've got to be in different venues in order to qualify for D. The one case that was filed in Windsor, I've got one case that was filed in Windsor venue, and Charlie Martin said, no, wrong church, wrong pew, and he said I should be refiling in Lamoille. I did. It was wrong venue, so that one does not count as what was not adjudicated unfavorably to me. It was just dropped because it was the wrong venue. So none of these 3 prongs, none of the 3 prongs in D are met. Unless you break the law by establishing a precedent, no one could appeal a divorce case in the same venue. In Knapp v. Dassler, Mr. Dassler filed multiple lawsuits in New Hampshire and other venues. I have not. Judge Bent used this Knapp versus Dassler example. And 1184, Rule 1184 was broken since I was not giving a hearing by the judge as required, and no request is needed for a hearing as per the law. He's supposed to give me that opportunity. I was never given the opportunity to be heard on abusive litigation. On we go from Judge Bent's 215-25 ruling on 147-10-17. The untiming the motion for a new trial. Divorce final order was 9/18/23. Case was then closed to any filing since it was at the Supreme Court at that time. The Supreme Court order was 7/12/24.
Appellant, 1 minute remaining.
You hear that, Mr.
Wow.
Orost? You have 1
Really,
minute.
that fast? Whoo-hee. Okay, well then I guess I'm done. I got plenty more, but what I'm saying is I only had 2 months to file, not 1 year, because the case was at the Supreme Court, and if I filed with the lower court, they would have just told me to go fly a kite. So I'm done then.
Okay, you're certainly free to reserve the rest of your time. We'll turn to the counsel for the appellee. Please For the record, introduce yourself, identify your client, and then proceed.
Attorney Charles Martin. My client is the former wife of the appellant. She has remarried and she is now known as Katie Audette.
Thank you.
As to appellant's argument, I refer to my brief where I indicate each one of the subparagraphs of section 1181 have indeed been met. As to Mr. Orst's complaint that he could file a motion for a new trial because the case was on appeal, a motion for new trial or amendment of judgment was already filed by his trial counsel and was decided by Judge Bent prior to the appeal being filed. I believe I've adequately dealt with that issue and the other issues raised in the appellant's brief. And I am available for any questions the court might have.
Okay. I don't see any hands. So thank you very much. We'll see now, does the appellant have any time remaining?
Appellant has 35 seconds remaining.
Mr. Orost?
Okay, 35 seconds. Unfinished discovery. Interrogatories still out. Interrogatories are still out for answers. We got no W-2, no witness. Contact data subpoenas were still out. Incomplete witness list, no expert witness for the supposedly coerced testimony. There was no data at trial about my health, and the judge just assumed that I'm going to be in a nursing home for some reason. I'm fine. And he also assumed that I'll be in jail for the rest of my life. I have a PCR that is going very well,
Appellant,
and
no
I will
time
not.
remaining.
Okay, thank you.
All right. Thank you, sir. Thank you very much. Please call the conclusion of the hearing.
The next hearing for the court is